Dear friends, today we will be discussing on the significance of Universal Declaration of Human Rights. The Universal Declaration of Human Rights was adopted by the United Nations General Assembly basically for the purpose of defining and enumerating the terms human right and fundamental freedom of individuals as outlined in the United Nations Charter. It is also a fact that the international community, after having experienced the most devastating First and Second World Wars, has adopted the Declaration as a global human rights standard. The Declaration has not only been a unique instrument on human rights, but it has also become the basic inspirational foundation for the global, regional, national efforts on human rights. A considerable amount of impact of the Declaration has also been found reflecting on various national constitutions and domestic legislations elsewhere in the world. Therefore, today every nation seems to have committed herself to observe and take appropriate measures individually or collectively for securing the universal recognition and due observance of human rights and fundamental freedoms of individuals as set forth in the Declaration. Now let us discuss about the significance of the Declaration. The Universal Declaration of Human Rights is globally termed as the Magna Carta of Human Rights, as it was one of the pathfinding major global achievements in the field of human rights. Even though the Declaration lays down a comprehensive human right and freedom of individuals, it does not stipulate the means or modes through which such rights and freedom shall be promoted and protected. The reason being is that the Declaration was primarily not intended to be a legally binding document, and as such, it did not impose any legal obligations on the high contracting states parties. Therefore, from the point of legal perspective, the Declaration was only a recommendation as it was not legally binding on the states party. However, the implication of overwhelming support of international community for the adoption of the such declarations, that is Judicial, inter alia its meaningful explanations and enumeration of human rights and fundamental freedom as outlined in UN charters, have shown the important characteristic of the Declaration. This has in fact created a well-founded obligation to be undertaken by the state party regardless of their different social, political, economic, ideology and cultural systems. Hence, it is clear that the content of the declarations are not only the message of hope, equality, liberation and empowerment, but they are also increasingly invoked and asserted within and outside the United Nations. They are creating a profound influence on the minds of the people of this world. In the matter of the legal significance and value of declarations, it is observed by many eminent writers of human rights expressing that the Declaration has created a new rule of customary international law. To mention the views expressed by then Judge Nagendra Singh of International Court of Justice, I quote, "The Declaration, therefore, was not a mere resolution of United Nations General Assembly, but a continuation of the Charter of United Nations and had a dignity of the Charters," unquote. Hence, it is not an exaggeration to state that any violation of the provision of Declaration can essentially amount to violation of the principle of United Nations Charter. In addition, some of the provisions of the declarations are found consisting of basic natures and characteristics of customary international law. So, henceforth, the content of the declarations have grown into customary law of the nation and thereby attributing the silent features of preemptory norm or jus causances. The World Conference on Human Rights held in Tehran in 1968 also observed that declaration has constituted an obligation for the members of the world community. Although such nature obligation is not defined, it is generally assumed that it possesses all the requisite features of customary rules, and it is also widely accepted as well as used as a parameter for assessing the conduct of the state's party pertaining to the promotion and protection of human rights in their national domestic jurisdictions. Now let us again look at United Nations initiative and measures so far undertaken by the United Nations in respect with the declaration. The United Nations proclaimed that people do have those rights and freedoms laid down in the declarations, not merely because they belong to a particular group or nation. This is mainly because the declaration applies to all human beings. The provisions of the declarations have been used as the basis for various initiatives and measures undertaken by the United Nations and its organs, more particularly in the post-1948. That is why the declarations itself remains to be the main source of inspiration for all the people and all the nations. It could also be an important message to all who are committed to freedom, justice, and peace in the world. On the other hand, in involving and developing the global human rights jurisprudence by the United Nations and its subsidiary organs, the content of the declarations are used inclusively by reflecting them adequately in a number of international human rights resolutions and documents. As such, UN declarations, conventions, and covenants adopted under the auspices of United Nations and other UN specialized agencies. The adoption of the United Nations Declaration on different aspects of human rights shows the positive measures undertaken in the field of promotion and protection of human rights by world communities. However, those declarations are literally not the legally binding document. As a result, during the passage of time, most of them have been transformed into binding convention or covenant by the United Nations General Assembly, reflecting the principles and content of Universal Declaration of Human Rights. In addition, the principles and content of the UDHR have also been found well reflected in a number of international specialized human rights documents adopted by the United Nations and its specialized organs. Now, let us discuss about impact on the regional arrangement. Though there is no specific provision in the United Nations Charter for making regionalism in the field of human rights, the idea of developing regional arrangement inter alia adopting the Regional Convention on Human Rights flows from the mandate of Chapter 8 of UN Charter. Eventually, the member states have also placed themselves under Article 55 of UN Charter as well as under the Universal Declaration of Human Rights to promote, achieve, respect for observance of human rights and freedom. Accordingly, some of the regional organizations of the world adopted regional conventions on human rights in conformity with the global standard. The actual initiative for the adoption of such regional arrangement, especially for promotion and protection of human rights, has been gaining ground since the adoption of UDHR in 1948 by the UN General Assembly. So therefore, the regional arrangement in the field of human rights reaffirm the provisions of UN Charters, inter alia the content of UDHR. As such, due recognition of human rights by the global community has virtually enhanced the growth and development of contemporary international relations and cooperation among the nations in all respects. To mention one of such regional conventions on human rights is the European Convention on Protection of Human Rights and Fundamental Freedom of 1950, which was the first ever adopted as a regional instrument on human rights by European Union. One of the important reasons for European nations to set up such a regional human rights arrangement was that Europe, being the main theater of two world wars and other man-made conflicts, it was felt necessary for the European community to have their own regional system so as to bring a concrete political, economic, and social unity and understanding in the region. In similar way, the American Convention on Human Rights of 1969 was adopted by the Organization of American States, in short OAS, reflecting the content of UDHR. The American Conventions enumerate the idea of free man enjoying freedom from fear both in the areas of civil, political, social, economic, and cultural rights, which are found more or less similar to that of provisions of the Declaration. The third such regional convention on human rights, which came into force after the adoption of 1948 Declaration, was the African Charter of Human and People Rights of 1986, adopted by the Organization of African Unity, in short OAU. The Charter was adopted with the aim to promote human and people's rights to ensure their promotion and protection in the African region. It is apparent that such regional arrangements reflecting the principles and content of Judicial are being set up with the aims to strengthen the respect and observance for human rights at all levels and all times. Interestingly, there is no conflict between the regionalism and globalism, especially in the field of human rights. This is mainly because both are found to be supplementary and complementary each other. It is also equally interesting to know that attempts are also being made to adopt regional arrangements on human rights in the Arab region as well as in Asian region. The working of the regional mechanisms under the regional instrument on human rights have adequately shown and proved that they could give effect to the rights and freedom of individuals proclaimed in 1948 Declaration in the respective regions. Now let us discuss about the Declaration of Constitution of India, the impact of Declaration on the Constitution of India. Many national constitutions were enacted elsewhere in the world after the adoption of 1948 Declaration. They are also found to be greatly influenced by the provisions of Declaration. For instance, in the National Constitution of Algeria, Burundi, Cameroon, Congo, Ivory Coast, Mali, Senegal, and India, among others. Although most of the national constitution and domestic legislation did not directly refer to the declarations, they were either found reproducing the terminology of the declarations or adhering to the provisions indirectly. Henceforth, it is evident that due to recognition has been given to the provisions of the declarations in almost all the national legislation which came into effect in the post-1948. Republic of India was one of the signatory member nations to the declaration. The Constitution of India was enacted and adopted by the Constituent Assembly on 26 November 1949, and later it was brought into force from 26 January 1950. Interestingly, when the 1948 declaration got underway for the adoptions by the United Nations General Assembly, at that point of time, the Constituent Assembly of India was preparing the draft for Constitution of India. As such, the Constitution of India was also influenced by the declarations. There were many constitutional provisions were found to be incorporated, giving due recognition to the provisions of the declaration. To begin with, the preamble to the constitutions lays down the dignity of individual, which implies that worth of inherent in human person is duly recognized and guaranteed by the law of the land. Those fundamental rights and freedoms embodied in the Part 3 of the Constitution of India are nothing but human rights in the context of India. Though literally the term human right has neither been used nor defined expressly in the Constitution, it is very much evident that the incorporation of Part 3 and 4 of the Constitution has indicated a clear constitutional mandate which gives effect to civil and political rights as well as economic, social, and cultural rights as enumerated in the Declaration. Such inclusion of both the set of human rights in the Constitution of India primarily took place even before the adoption of the 260th International Covenant on Human Rights adopted by the United Nations General Assembly in 1966. Now let us discuss about the judicial response in this regard. The international treaties are not the self-executing document in India. This is mainly because of the constitutional mandate as provided in Article 253, which empowers the Parliament to make appropriate legislation for implementing the global agreement or conventions in the domestic system. So therefore, the judiciary in the Commonwealth countries like India interpret their constitutional provisions by relying on the charters of UN as well as other international human rights instruments. That is why the Court of India have been interpreting the text of Constitution liberally by referring to the Universal Declaration of Human Rights. For instance, the Supreme Court of India held in People's Union for Civil Liberties versus Union of India, 1972, that the rules of customary international law, which are not contrary to the municipal law, shall be deemed to be incorporated in the domestic law. In the Kesavananda Bharati versus State of Kerala, AR 1973, the Apex Court also held that this court must interpret Article 51 of the Constitution in the light of the UN Charter as well as the Universal Declaration of Human Rights. The same court in Jolly George versus Bank of Cochin, AR 1980, that the declaration has not created a binding set of rules. However, international binding treaties have stimulated and informed the national judicial institution and also inspire the national legislative action. Similarly, in Kisorsan versus State of Himachal Pradesh, 1991, the Apex Court held that declaration has great influence in the interpretation of Constitution of India. Therefore, it is clear that the prevailing juridical approach of India shows the progressive development and growth of human rights jurisprudence over the domestic legal order in compliance with the global human rights standards and norms. The Universal Declaration of Human Rights set out a comprehensive list of rights and freedom of human beings, but it does not stipulate the means and modes through which these human rights and freedom shall be taken care of. It is also equally true that declaration does not have the force of law. However, it bears not only moral obligation but also legal obligation of the state party which have accepted to abide by the UN Charter, inter alia the rule of customary international law. The declaration has undoubtedly provided for a global standard as well as universally accepted path-finding instrument on human rights that ought to be recognized and guaranteed by all people and all the nations. In similar way, the provisions of the declarations have been found well reflected in the Regional Convention on Human Rights as well as in several other national constitutions of the country of the world. This viewer, thank you very much.